Hello everybody, my name's Rhiannon Hardy. I'm a planner here at the Department of Planning, Transport and Infrastructure, and I'm here today to talk to you about assessment pathways. So you might be aware there's currently a technical discussion paper out on public consultation titled Assessment Pathways, How Will They Work? So in this video I'm going to go through what the various assessment pathways are, which basically shows how development applications will be processed under the new Act. What are assessment pathways? It's essentially the processes that an application goes through from lodgement to decision, and even prior to lodgement, so preliminary advice, once it's lodged, who is the relevant authority, what is the assessment category, what referral agencies can contribute, and then whether an application requires notification, how it's notified, who it's notified to, all the way to assessment panel meetings and a decision being issued. There are 3 categories of development in the new planning system under the PDI Act. The first category is accepted development, and that's similar to what we call Schedule 1A applications in the current system, where no planning assessment is required, only a building consent where necessary. These categories will generally include anticipated structures, which are common in their circumstances. So that can include carports, garages, swimming pools, etc. The second category is CodeAssess Development. That's also broken down into 2 subcategories. The first is deemed to satisfy development, and the second is performance assessed development. Deemed to satisfy development is development that must be granted planning consent. So it's meeting clear prescriptive criteria in the new planning and design code. It could include things like standard residential development, new houses, and that will be determined in the future planning and design code. The second subcategory of code assessed development is performance assessed development. Now this type of development is really the default category, so where it doesn't fall into any of the others, it will be performance assessed. Now that means it's assessed on its own merits against the planning and design code. The third and final category of development is ImpactAssess Development. That's further broken down into 2 subcategories. The first is restricted development, the second is ImpactAssess Development. Restricted development will be defined in the planning and design code as being restricted. So that could include specific types of development. Restricted development is something that doesn't neatly fit within the zone or subzone that it's in, and it requires a higher order of assessment than code assessed development, which is something that is assessed on its merits. The final subcategory of impact assessed development is just what we call ordinary impact assessed development, and that's the highest order of assessment, and that's something that is declared in the regulations or declared by the Minister as being impact assessed, and will follow a pathway that requires an environmental impact statement. Firstly, when we say category, it no longer refers to category 1, 2 or 3. The categories of development are now simply accepted, code assessed or impact assessed. Public notification will simply be required or not, and will be undertaken in accordance with the legislation depending on the category of development. For restricted development, you may think it sounds a bit similar to the current non-complying development process under the Development Act. There are some similarities, but one of the key differences is that there's no longer a mandatory concurrence process, either through the Commission or through Council. That application is assessed by the relevant authority the whole way through. For relevant authorities, there are some key differences from the Development Act. One of those main differences is that Council itself is no longer the authority for issuing planning consent. It's actually the roles of people or bodies who can work within that council who will be the relevant authority. So that can include an accredited professional, an assessment manager, or an assessment panel who are actually the decision maker. Councils will still be responsible for issuing development approval and for undertaking building assessment in the relevant circumstances. One of the other differences in relevant authorities is that under the impact assessed pathway, the minister will be the relevant authority, whereas under the current system, the governor was the relevant authority for the major development process. With public notification in the new system, there are some key differences from the Development Act. The first of those is that the definition of adjacent land has been simplified. It now means any land within 60 metres of the subject land. Another difference that everybody has probably picked up on already is that there will be a physical sign put on a development site, which, when compared to the Category 3 procedures under the current Act, will replace newspaper advertisements, which can quite easily be missed. But now under the new system, all people who regularly interact with the site will be able to clearly see when a development is proposed. In terms of the procedural matters in what happens with development applications as they're assessed, there are some new initiatives in the PDI Act. One of those is outline consents. So that means that an applicant can apply for an in-principle consent before they lodge a formal development application with all the relevant details and specifications. However, outline consents are only or can only be lodged in circumstances that are anticipated by a practice direction that's issued by the Commission. So the practice direction will detail perhaps what types of developments or in what locations that an outline consent can be applied for. Another new initiative under the PDI Act is deemed consents. A deemed consents is where an authority has exceeded the time frame prescribed to make a decision on an application, and at that time or after that time, an applicant can serve them a notice, which is taken to be a deemed consent. If it is the case that the authority believes that consent should not have been granted, there is an opportunity to appeal that to the court. Another change in the PDI Act is that consents can now be obtained in any order. This means that if an applicant wishes to obtain building consent before planning consent or apply for them at the same time, they can now do so. After a planning consent is granted, there are then some new procedures in the appeals processes. A decision of an assessment manager can be appealed to an assessment panel. This avoids the need of going through the Environment Resources and Development Court for matters that could be resolved outside of the court process. A similar appeal process applies for restricted development applications, where the Commission's delegate has resolved not to proceed with assessment. The applicant then has the opportunity to appeal that early no to the Commission itself. The third key change in terms of appeal rights is that for performance assessed development, there will be no third-party right of appeal for representors to a development. In this video, I've provided you with a summary of some of the key technical changes in the new system. So what does that actually mean? Well, it's providing a simpler system. It's making the process easier for both applicants and authorities, making sure that the level of assessment matches the complexity of applications. So authorities shouldn't be able to get tied up in procedural matters, extending the assessment timeframe for applications that are really quite simple and should follow a streamlined process. Alternatively, applications that are more complex will follow a more rigorous assessment process. At the higher end of the assessment process, there's going to be targeted public consultation. So people will be notified of the development, they will physically see what's happening with the notice on the land, and they'll have input into the development application process. There is a technical discussion paper currently out on public consultation. This period is really exciting and important for us because the feedback that we're getting through this discussion paper will help us write the regulations which will prescribe which relevant authorities assess which categories of development, how public notification is undertaken, and other key questions which are identified throughout the discussion paper. So if you haven't seen it already, I really encourage you to download a copy and continue the conversation with us here at DPTI.